welcome to our second webinar, Wills and Trust, which promises once again to be a very informative and of course life-changing experience, teaching you how to put all of your, as the people will say, all your ducks in a row to ensure that your desire is carried out after you would have passed on. We are streaming live from our WESCU headquarters, situated at number 45th Street in Woodbrook, Port of Spain, Trinidad and Tobago. And as usual, as is customary, we always like to include the Holy Trinity in anything that we do. So we would start off with the Synod prayer, which is a prayer that I love very dearly, and we will start our prayer now. So we stand before you, Holy Spirit, as we gather in your name, with you alone to guide us. Make yourself at home in our hearts. Teach us the way we must go and how we are to pursue it. We are weak and sinful. Do not let us promote disorder. Do not let ignorance lead us down the wrong path, nor partiality influence our actions. Let us find in you our unity so that we may journey together to eternal life and not stray from the way of truth and what is right. All this we ask you, who are at work in every place and time, in the communion of the Father and of the Son, forever and ever. Amen. And as usual, this prayer is said with no disrespect or discrimination to other religious beliefs. So this evening, ladies and gentlemen, we have with us, to my right, we have Ms. Anne-Marie Francis Charles, and she's a member of the Board of Directors of Western United Credit Union. And we have to my left, Ms. Joyce Lynch, who is the second substitute of the Board of Directors of Western United Credit Union. Both ladies are indeed attorneys at law. We also have a special guest this evening with us, Ms. Sonel David Long, attorney at law, who is joining us online this evening. So as promised, and I welcome all of you ladies. Thank you very much for joining me. Sonel, thank you so very much for joining us this evening. I know that you were unable to make it the last time, but here you are. So thanks very much for your presence. So Anne-Marie, the last time we spoke about an executor and an executrix. Just for recap and for maybe some persons who are joining us for the first time, if we can just get an appreciation of what is an executor, what is an executrix, and why it is important to have these persons within the will, and what are their roles and functions.
Well, Mark, executor, executrix is simply male, or the male name executor, if it's female, executrix.
Yes.
But essentially, the executor is the person who is responsible for carrying out the wishes of the testator.
Yes.
As identified in the will, which is essentially distributing the assets, paying whatever debts associated, and just to make sure that the estate, the distribution is in accordance with the wishes of the testator.
Mm-hmm.
As I said in previous, it's always good to name a person by name, but sometimes it can be implied, in terms of the wording.
Okay.
Yeah, you may not say that I specifically name so and so, but because of how you word the will, you may say, this person is to do this, that, or whatever, and it's implied that this person will now perform the role of the executor or executrix.
Or the executrix. Ms. Lynch, you have anything to add there?
Not really.
Not really.
No, yeah.
I think we covered it very clearly.
Yeah.
So This is a new question that I want to ask, and I'm just going to throw it out for Sonal could start the ball rolling in terms of what makes a will valid, or what can revoke a will. If a will is not, we did the will goes before the court, and maybe the person did not carry out a particular function, and before the judge, and the judge looks at it, he says that, okay, this will, in my opinion, is not a valid will that can be carried out, or can be upheld.
Yes. Mark, so two things. First of all, I just wanted to, before I answer that question, just add that it's always advisable that you have more than one executor or executrix. Just to add to what Anne-Marie had said, it's always advisable that you have more than one, because you don't want to be in a situation where your executor or executrix does not want to act, and you are left with your will and nobody to run about and go to the bank and do the letters and go to the lawyers. It's always good to have more than one person. It's always good to have somebody that you think, of course, you can't predict it, it's not going to predecease you. So you probably don't want to pick your grandmother to be your executor. You want somebody who is going to be able to do it, carry it out, and probably, in all likelihood, not going to predecease you. So I just wanted to add that bit in terms of the executor. Now, so you have your will, you've created a will, you've signed it, you've done everything. What can make it invalid or unenforceable? The first thing is a witness being a beneficiary. When you're choosing your witnesses, they must be persons who are not named in the will, who have nothing to get, receive, no financial or other interest in the will, direct or indirect. Why is that so? If you have a will and you have someone who has signed the will who is supposed to get something, that may raise an issue of whether there was any undue influence, whether that person came to make sure then that you give them what you say you're going to give them, things like that. In addition to that, just apart from witnessing the will itself, you don't want your beneficiaries to be present at the time that you're signing the will. So I've had situations when persons came to sign, and if it's your favorite son or whoever you want to give the will, I don't want them in the room with you. Create some distance between the persons who are to benefit and you, so that it does not appear that someone is influencing you in terms of what you want to do with your property. So the principle, and you're probably getting it from both the examples I give, you want to avoid any suspicious circumstance that evidences duress, undue influence, fraud, anything like that will invalidate your will.
You ladies who are in-house wish to jump in?
No, I think she adequately, identified, because you don't want to raise, as she said, issues of influence, and someone want to file a caveat against the court to challenge. Yeah, and they would also look at, if the the act was complied with in terms of the stipulation where the testator signed, and so things like that.
Yes.
In terms of the formalities.
Ms. Lynch?
Yes, I agree with both ladies.
Okay, okay. And I guess if I can't remember hearing, in terms of soundness of mind, if it can be proven that someone was not in their right mind or suffering from any mental illness, that can also make a will invalid.
But that would be covered under undue influence.
But someone will have to challenge the will and to the court, alleging that the person was not in sound mind at the time of making the will. That's what we call animus testanda. It must be person, the testator must do it of his own
Of
free
his own
will.
free
He
will.
must know what he is doing, and he must have knowledge of, exactly who he is, bequesting his assets and his beneficiaries to, without the influence of an external person. So whatever bequest and legacy he makes in his will, he of himself must know that, or he owns this, I am giving this to this person.
Yes.
So as I said, he must, in his right mind, as they want to say, at the point in time when he's making the will.
Well, yeah.
That is his decision
Yes,
was
it is right.
But this is
sound and valid.
At the point in time he's
Yeah.
making the will.
Yes. Sonel?
I'm agreeing with what was said. It's actually, when we think about mental competence, you consider it really in the textbook way as a prerequisite to being able to make a will. You can't make a will unless, and the test is actually, I'm sure my fellow panelists will agree, is a very old and popular case, Banks and Goodfellow, where the rule is a testator must have a sound and disposing mind and memory if you're going to make a will. So there are 4 things that you need to have, and we did allude to them, to show that you had the mental capacity to make a will. You must understand what you are doing, the nature and effect of what you're doing. That's number 1. Number 2, he must recollect what property he possesses. So if someone comes to you or someone is making a will and he does not even know what he has, that is a red flag. He must know who he intends to benefit. So this is what I have, and these are the people that I want to give it to. And he must be not only clear with what he has and who he wants to give it to, but how exactly he wants it to be distributed. So those are the 4 things that the court looks at to confirm that the person has the mental competence, the animus testandi, to make a will. The 4 things are, first, he must understand the nature and effect of what he is doing. He must know he's making a will. So he must not think he's signing a deed or anything else. He must understand the nature and effect of what he's doing. He's doing a will, and this means that when I die, this happens. Number 2, he must recollect what property he possesses. Number 3, he must know who he intends to benefit. And 4, he must be clear as to the manner in which he wants to distribute. So those are the four things the court looks at.
Slipshot kind of thing that you're entering into. You must be of a free mind, sound mind, understand what you are getting into, know very clearly what it is you want to leave for whom, and know your assets.
Exactly, yeah.
So you can't say that you want to leave X, Y, and Z and you don't know what it is about or if you have it or anything like that. One of the things that I want to recap, I mean, we discussed it the last time, but I want to talk about it again because I find it to be very important. And one of those things, Sonal, is the deed of gift. Someone leaving, gifting something to someone before they actually expire. And in my mind, we had a good conversation with this the last time, because in my mind I'm saying that can be a very troubling, and it's like you're shooting yourself in the foot if something goes wrong or you wish to change your mind, that this person whom you have gifted your property or gifted something to, maybe to hold for a particular period of time, and in conversation with Anne-Marie, it is not so easy to get back. Because in my mind, in my mind, I was saying, well, okay, I gifted it to you just to hold, So it really doesn't belong to you. So if it is, I want it back now, it's just an easy process because it doesn't belong to you. So then what are your takes on that? Your take on that?
I feel like Anne-Marie has already said everything that needs to be said there from what I heard in the discussion. I was just laughing along with y'all because it's really a double-edged sword. The security
Yes.
that you have with a will is that, and just this week I was saying it to a client, you could change it every day if you want, you know. You could wake up the day before you die and say, well, I don't want to give this person this anymore. And that would be it.
Yes.
It nothing happens. It does not take effect until you die. So you can change it. But on the other hand, I have seen it very, very effectively used when persons have gifted property to their children whom they love and trust infinitely, and the children
Mm-hmm.
have not kicked them out before they died, and it has saved them having to do any administration and work after. But the question is, do you have money for stamp duty? Because if you're gonna gift, if you're gonna make that conveyance during lifetime, you have to appreciate that it's going to attract stamp duty. And I think we all know that stamp duty could be quite hefty. If you have a property that's, let's say, 1.5 ish, you don't quote me on this because I haven't done the calculations. It could be in
Yes.
excess of 28,000 or more in terms of the stamp duty. So if you are starting out, one of the things you can do, and my husband and I have done this, we've started to put everything jointly so that regardless will or no will, we have ensured that as we convey and as we do things, they are joint. But
Mm-hmm.
I've also known persons who have, for instance, said, I'm going to keep a life interest in my property, and then I remain the interest to my children so that I retain an interest during my lifetime. And when I die, then the children or whoever will have the ability to use the property so that they can't kick me out. But what that also does, it gives those persons who have the remainder interest a say, a seat at the table, because they now have an interest. They are going to benefit once you die. So they now have a seat at the table. You can't just sell it without saying anything to them. Okay, so like I said, from what you mentioned, it seems like Anne hit the most important thing, which is if you want to be able to have the flexibility of change up to the time until you die, because who knows, a will is the way to go. Also, if you want to avoid stamp duty, a will is the way to go.
Thanks very much, Sonal. Because in the discussion, because a family member passed away, and of course, in the credit union, you have what you would call the letters of administration. The beneficiary comes in, they get the $50,000 as the law states, and anything thereafter, you do letters of administration. And the person was talking about the deed of gift. And I became very concerned about that because, and especially after our discussion, Anne-Marie, thinking that, okay, the deed of gift, and it's easy that you leave it there, you gift it. So if anything should happen to you, that the person to whom you're leaving it to would not have to go through any letter of administration or anything. It is just easily transferred to them.
No, but,
Yes?
with the deed of gift, it takes effect on execution.
Immediately.
Yeah, like it's a conveyance, you pass the title to the property, it's registered, it passes to the person who now becomes the owner
Mhm.
while you're still alive. So you
So,
essentially pass all your interests on to the with the as I say, the deed of gift.
yes.
But people think that they may not have to pay as Sonal said, stamp duty.
Hmm.
But you do have to pay
This
depending on
time.
the value
Hmm.
of the property, because you're still required to do valuation
Hmm.
of the property.
So
If I
that.
may,
Hmm.
sorry.
Hmm. Go ahead, Ms.
Well,
Lynch.
if I may, there are instances when I'm just speaking from my own private perspective. You if you die intestate and you have an adopted child, that child will never be able to share in that in your property because they are not considered next of kin,
Even though they are legally adopted.
even though they're legally adopted. So
Okay.
I feel I'm of the view that I'm subject to correction by Sanel, however. I'm of the view that it might be one instance where it might be safe to give an adopted child a deed of gift, which even if they mistreat you, you know that if you don't do that, they have nothing to get if you died intestate.
Well, and that is one of the reasons Sonal said, the preferred way is to do a
They
will
will.
before. I say we don't know when we're going to kick the bucket, as it were.
Yes.
So if you know all those situations, the issues may arise. You, as you said, you have control. While you're alive, you have control. While you have the mind and the mental capacity, you do a will. So your adopted child would benefit.
But
Okay.
even what Miss Lynch just mentioned, it makes it even more troubling to me that the law does not or would not recognize a legally adopted child
That's the next of
as a next of kin,
So
and
not
if
blood relation.
not blood relation. Okay, but I'm legally adopted, Anne-Marie.
but
Sonel, I'm
they can
legally
do.
adopted, Sonel.
My understanding
Let
is
me
that,
hear you, Sonel.
hi, yes, interesting. My understanding is if you're legally adopted, you're considered a child. So that should ordinarily deal with the relationship. You're considered a child of the family. So I was not aware of a situation in which the adoption affected your ability to claim as a child because it's a legal adoption. If it's not what we do sometimes when somebody lives with you forever and you say this is my son, but it's not actually a son. If you're legally adopted, then you do assume the rights of a child. The status of children's action allows you then to assume the full rights. That is my understanding of the law as it currently stands. But I'm also happy to, based on what Ms. Lynn said, take another look at that. But that is my appreciation of the state of the law at present.
That is another one question that we may have to come back to answer, or maybe
Yeah.
post an answer on Facebook or on the website to give some clarity. Because in my mind, I am saying if I am legally adopted, it means that all rights and privileges that a blood relation, a next of kin would enjoy, that I would also be entitled to that as well. So
Well, we
I,
can look at it again.
I would certainly like to have a greater appreciation of
that,
that. Yes.
I never really considered as Ms. Lynch said in terms of an adopted child. But I mean, under the law, they talk about the kin being the issue of the disease.
Yes.
So essentially, that refers to a blood relation.
Blood relation.
The disease, the father, the mother, some blood connection. While adopted child is not really blood related. So I'm seeing it from that perspective.
Okay.
That if that is indeed so, there need for some sort of amendment.
And I would say so too. Just as how there should be some kind of amendment that I don't necessarily only need to leave a will in writing, but I can make a video leaving a will. Because that was one of the questions that I asked the last time, Sonel, And of course, Anne Marie said, no, 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 only in writing.
And
You can't
under
do
the
no
law.
under the law.
Yeah.
You can't do any video. You can't do any audio leaving a will. So if I am dying and I did not have a written will, but I have my phone and I want to do a little WhatsApp video, or call Anne Marie fast, fast, fast. Anne Marie, come and record this for me. Because I want to now say, listen, I didn't do it when I was healthy and I had my mobility, but now I'm saying I want to do it now, but I can't leave the house. And I'm thinking the way how I'm feeling physically and mentally, I can feel that I am going, I'm expiring. Uh, that is an amendment, I think, that we need to address, that I can leave a will, at least locally.
Mhm.
I think maybe in abroad, foreign, that you can leave a will via video. Sonal, what are your thoughts on that? Well, I know Sonal going to say the same thing.
I think the lawyers are sticking together here because
You
I
see what I
understand
say?
technology and everything, but there's certain risk associated with not
Mm-hmm.
doing certain things in writing. And as traditional and outdated as it may seem, think about, for instance, the way that videos and video technology can be manipulated. Even sometimes you have an account and you think it's your account, but there's a lot of hacking. Somebody could set up an account in your name. So you did your last Facebook Live, and Mark, please understand, I'm not calling death on you at all. You did your
Not at
Facebook
all.
Live. Please, guys, I'm expiring. This is what I want to happen. And then for all you know, is not your account, you know. So there remains a certain protection with doing it the old fashioned way. I suppose if ever we move towards having wills done by other means, it'd have to be a lot of protections. I am not sure we're there yet in terms of the kind of protection we would need to ensure that a will done in that way. I mean, just think about it. Where are you going to store it? How are you going to access it? As opposed to here, you do a will, somebody puts it in a safe deposit box. People may still lodge it at the registry if they wish.
Mhm.
So I don't think we're there yet, Mark.
The lawyers are ganging up on me, boy. No, but yes, clearly, and I understand and I appreciate that, but I was just thinking, sometimes from a layman's perspective, you would feel that, okay, I need to have this done now. I don't have the time to write, so I'm going to do the video. And of course, what you had mentioned there as well, Sonel, in terms of the doctoring of the videos and all of those things are things that we would have taken into consideration. But thanks very much for your input. When we left off the last time, we were trying to get some kind of clarity in terms, and we were discussing it before coming live, in terms of you have a situation where a legally married couple decide that, listen, we cannot make it anymore. It is best we go our separate ways. So they approach the family court and they apply for a legal separation. And what that simply means is that, okay, fine, we are separated, but we are not married, no longer married, but we are not divorced either. Seems kind of confusing, eh? I hope I'm getting it right, eh?
You're still legally married.
Yes.
You're probably not living
Mm-hmm.
together. You're
Together.
legally separated, but you're still, once the court has not pronounced and issued a decree absolute,
Mm-hmm.
you're still legally married.
So you're still legally married, but you're legally separated.
Yes.
What does that mean, to be legally separated?
essentially the court has, given an order recognizing that the two persons are living separately and probably no longer living within the same household.
Mhm. But it's just to
Okay.
interject, Anne-Marie. So, but can I be legally separated and still living under the same roof?
Yeah.
You stay on that half of the house, and I stay on this half of the house.
Well,
I think it
they're
would
not
work.
living as husband and wife.
No. Mm-hmm. I just causing
I know, I
a
know,
little
I know, no, but I
confusion.
know persons who are, divorced and still live within the same house.
Divorce?
Yes, divorced. There are couples who have been divorced and still reside because no one wants to move, and no one is able to compensate the other party
Yes.
for their share. What is Sonal's take on?
Well, let's bring in Sonal here.
There's a part of me that's really regretting not being physically there with y'all. As the young people say, it's a real vibe down there. Oh my goodness, y'all are hilarious. But and I also find that Mark is doing a very good job of asking some very interesting questions.
Sonal.
In this jurisdiction, you either married. If you're not married, you get a divorce.
Mhm.
Our courts don't, as in the US, say that you went and you got this separation order. That is not something that is done here. People separate, as in they move away and they don't live together. In fact, as was just mentioned, you can be living under the same roof, but if you are leading separate lives, that could be a ground for divorce. The court will say that you do not have consortium vitae is the fancy term, teacher. You're not living together as man and wife. But
Mhm.
it's either you're married or you're divorced. You could live wherever you want, but we're not really like the US in that way. When you go and you get this, you're separated, but you're not. Here is either you're in or you're out. The only period of separation per se is probably between the time that you're waiting for your decree absolute. But even then, I don't think it is a separation or in the US sense of you get a legal separation. That is not how it works here. We are very black and white down in this region. It's the same way. For instance, I know I'm digressing. You don't have a living will in Trinidad and Tobago or in the Caribbean. You're either alive or you're dead. You don't have a living will that you make a will for somebody to do something while you're not competent in that way. There's something to deal with it under the Mental Health Act. But we tend to draw our lines very clearly down on this side.
Mhm.
Okay, so as it pertains to that separation issue, yeah, you don't really have the position of legally separated. If you're married, that is your legal spouse until you obtain a decree and that person is no longer your spouse. So that's the first thing we need to get out of the way in terms of how they relate.
So in Trinidad and Tobago, we don't have anything like legal separation. According to what Sonal just said, is either you are married or you are not married. It's either you're divorced or you're married. So before I go on with that question, I'm seeing that Ms. Claudia Phillips, she is back in. I will come to her in a little while. Let me check the chat. I am seeing here, well, of course, good evening and good evening to the person that asked the question. Thanks for this session. My question is, if someone survives her 3 children but eventually dies without leaving a will, who becomes her next of kin to benefit from the estate? Her grandchildren or her siblings? The floor is yours.
Read the question again now.
All right, let me take it. Let me read it again. The question is, if someone survives her 3 children but eventually dies without leaving a will. So I a parent.
Mhm.
I have 3 children, Brian,
So it means the person.
Trevlon,
Mhm.
and Mr. Mr. Vatas. So those are my 3 children.
Mhm.
And then
Mhm.
I survive the 3 of them. So they come and
Or
they
parent
pass on.
died.
Yes. And then after that now, I come and I die. But I die without leaving a will. So what the person is asking, who becomes the next of kin to benefit from the estate? Is it the grandchildren or the siblings? Because remember, the children are out of the way. I would have left my assets to my children, my 3 boys.
Right, right.
Then they pass on, then I came now and I pass on without leaving a will. So therefore I have grandchildren. So who, without, there's no will, everything I think is left to the estate now. So who
Well,
would benefit, the
person died.
grandchildren or the other siblings, my brother or sister?
Well, who can not only benefit, you'll
The
have to see who
loss
can
has
apply for letters of administration would be the brothers,
yeah,
the brothers and sisters
siblings.
of the deceased.
Mhm.
They have
Not the
the
grandchildren.
no, they are first in line in terms of applying for letters of administration. For the-
I might tell them agree because I love my grandchildren.
No, and
But
they
they
are
will
the
have.
ones who can apply for the grant.
Yes.
Right.
Let me bring in Sonel. Sonel?
So one of the things, and thanks for the question. If you decide that you are not leaving a will, or if your will is invalid, your estate, you die intestate. That
Stick a pin there, Sonel, and just briefly reiterate to us what it means when a will is invalid, to tie it all together. We may have forgotten what it means for a will to be invalid.
So let me take it from the top again. Now this person has died without leaving a will. That's the main thing. I know you're asking grandchildren or siblings, but the pith of the question is what really happens? How is your estate distributed if you die without leaving a will? First of all, it is not just if you die without leaving a will that you die intestate. If you create a will and your will is invalid, either because you did not have the competence to create a will, you're underage, you were not an adult, that's another important thing. You have to be a minor, cannot create a will. If you did not follow the formalities, if you signed it at home by yourself, you had no witnesses, nothing like that. Or if your witnesses were beneficiaries or you had those other suspicious circumstances, your will be invalid. So you didn't execute a will, your will was invalid, or your will was revoked. So some people revoke their will and never do another will, so they have no present will. In whichever of those situations, then you die intestate. If you die intestate, the Distribution of Estates Act kicks in. And that act gives you an order of priority of how your estate is going to be distributed. It first goes to your spouse. If you have no children, all goes to your spouse. If you have children and no spouse, all goes to your children. And the act is freely available on Google. Just Google it and you will see the section that gives you the whole order, and it's a long list straight down to who could get it and who can't get it. If you have one child and a spouse, it goes half and half. If you have a spouse and more than one child, but after you pass spouse and children, parents. So if you die, no spouse, no children, your parents are next in line. If you die, no spouse, no children, no parents, your siblings are next in line. So in that question, the person who is higher up on the list is your siblings. Yeah, just going down that. But I also need to stick something else here, something else in here.
Mm-hmm.
Because, so I was just there, first of all, give you the general order of how it goes. Now, if you die, leaving a spouse, no children, everything to spouse. If you die, leaving issue, but no spouse, everything goes to your issue. Where the children come in, and this is by virtue, I'm trying to pull up the act as we speak. There's something called prestirps, S-T-I-R-P-E-S. What happens there is if you have, let us say that you die and you have 3 children. I can't remember the name of the children, Mark. It was Brian, Teflon, and something else. Say one of them dies, I'm not going to pick which one. And they leave 2 children. 1/3 share is going to go to whichever, the first one. 1/3 share is going to go to the second one. But, oh gosh, I think I will have to pick one. But Norman's 2 children will end up getting his share and picking and splitting it in half. Because his share doesn't just disappear. That is where the grandchildren come in there. In that situation, they stand in the place of the parent who is no longer there. I know it is mildly confusing. And as I said, the act goes all the way down. It says, after them, after parents, brothers and sisters of the whole blood. So you haven't reached the stepbrothers or sisters yet. If it's no brothers and sisters of the whole blood, of the half blood, so that's your stepbrothers, stepsisters, all sorts of things. I know my 2 co-panelists, they have probably also seen this long list, and then nephews to the whole blood, of the half blood, grandparents, no nephew. Oh my goodness, it just goes on.
It goes to aunts and uncles.
Yes, yes.
Yeah.
So if you don't create a will, it's going to go down the list, but it's going to go down in that order. So it's not going to be a blanket question. It really depends on who else is there and who else falls in that category down the list generally. The most important thing you need to know about that is if you do not create a will, then your property is going to go down in this way. And that way is also, it's drafted to sort of benefit persons that in the way you may ordinarily benefit them. So that if you die without a will, and you have a spouse, it's likely that everything will go to the spouse. If you die with a spouse and children, it's likely that you will want everything to go to your spouse and children. So it is not random at all. It's very deliberate in trying to provide for people in order of priority of kin, so to speak. I feel like I've said a lot, maybe too much. I hope it wasn't confusing to the person asking the question.
Thank you so much, Sonal. As a matter of fact, it brings greater clarity because in terms of the, well, how we call it, tier order of how it is supposed to be distributed if you didn't leave a will. But one of the things that came to my mind as Sonal was speaking is that, and we alluded to it in the last webinar, is that leave a will because you don't want to turn in your grave, because I may have a favorite son, although you wouldn't want nobody to know. I have favorites, and I really want this person to get this portion of my assets. So to ensure that, and to ensure that my desire is carried out, the best thing to do is make your will and ensure that it is authentic and that it is well structured and it is legal, that no one can contest it, so that your child or your children who you want to get whatever assets, get the assets.
And what I have found too, that where persons do not make will and they have died intestate, sometimes the family do not know what to do.
Mhm.
They don't take action, and sometimes the estate or if the person have land, people just take and become they start to occupy the land.
Mhm.
It passed to this one, that one, with no real legal title. There are instances where people may have family land, well, what we call family land. I
Yes.
know of a friend who have land in Tobago, and because over time, generations, no one took action with respect to going through the process of administration.
Mhm.
Persons occupy the land. You don't know who's on the land now, and now nobody wants to take action because one, there's a cost,
Mhm.
and the effort to go
Mhm.
through in terms of tracing. And what I like to do, you have to now go through the family tree to see who really, is entitled,
Mhm.
coming down through generations. And it's time consuming, it's going to be costly. So I always advise, do what is necessary, make the will, especially when you have a lot of land in the family.
Mhm.
And in this case, the co-worker is Tobagoan, so they have land,
Mhm.
but don't want to
No one
action.
took
Yeah,
action
yeah.
or
So it's just
possession of
there.
it.
People start to squat,
Yes,
and
which makes it even
yeah,
more difficult for you now if you want
yeah,
to get a hold of it. Because if people start to squat, that land could become
yeah.
legally
People have
theirs
to,
after a certain
yeah,
time.
adverse possession. They want it. So and then nobody wants to take action because nobody wants to invest the money necessary to do the legal work to
Mhm.
to bring everything to
Mhm.
to a certain state.
So, in other words, just make a will.
Yeah, unless you have a large estate, when you start to go down the line as in the
Mhm.
law, a person might get 130 something, one something. But
Next
it's
to
not
nothing.
next to nothing because it's not
Yes.
really a physical share you may get. It's
Yes.
a
So, in other words, people, just make a will. Right? So when you pass, well, you wouldn't know what's going on, but at least you know you left something in place. And you alluded to it the last time, Sonel alluded to it this evening, is that you could change your mind.
yeah.
And Sonel even zeroed in that I could change my will every day. I mean, that might be an
Yeah,
exaggeration,
but I mean,
but it just shows you that you have the legal
control and
right
you
and
are exactly.
control that, okay, I can change my will next 2 days. All right, I ain't like how Joy's behaving. I'm naughty girl for the past 3 weeks. She not listening to me. All right, I taking you off my will this week, and I might put you back on next month. So, folks, we are going to a commercial break. I know it has been a lot, and we will be right back. What are the threats to healthy relationships?
The nature of a relationship is to be equitable. And in an abusive relationship, we see the corruption of that equitable nature of a relationship where there is this space of power and control that's entered, where one partner feels entitled to punish or regulate another person as a way to dominate them. So there is a pattern of violence when a partner becomes defensive, or when they stonewall, meaning that they just shut down. There's no communication happening. So all of these things can interplay and really erode the quality of the relationship.
what is a will and why it is important that an individual must have or make a will.
A will is really an expression, a documentary expression of an individual's wishes or desires after he dies, what he wants to happen with his property, his assets, who he wants to benefit when he dies. It's important because it gives the individual or the testator control of his assets, control of his estate in terms of who he wants to benefit and what he wants to give to that person or persons.
So that my wife and my children or whomever I am living with
will
be taken care
right.
of. Good evening, ladies and gentlemen, and welcome back. Welcome back to WESCU's webinar entitled Wills and Trusts. And for those of you now joining us, we are streaming live from Western United Credit Union Studios, situated at number 45th Street in Port of Spain, Trinidad and Tobago. And as I just, sometimes when you're live, things just happen. I'm fighting to get the little notes here and it ain't coming up for nothing. So we had some very interesting, oh Lord, people bear with me. Every time I highlight, okay, great, I have it now. So we have some very interesting conversation before. And just to introduce you to our panelists, once again, we have to my right, Ms. Anne-Marie Francis Charles, attorney at law, and a member of the Board of Directors of Western United Credit Union. To my left, we have Ms. Joyce Lynch, who is also an attorney at law and the second substitute to the Board of Directors. And joining us online, our special guest is Ms. Sonel David Long, attorney at law. So I hope that answered your question, and I am going to assume that question was from Ms. Claudia Phillips, and I hope that would have answered your question. Before we jump back into another question, and I'm seeing it's after 7 already, so the person is asking, had a common law wife, no children, how does she fit in? He did not have a will. Anyone?
That is the question?
Yeah, that's the question. Had a common law wife, so I'm thinking that the person had a common law wife. They had no children. And how does she fit into the matrix of obtaining his assets because a will was not left? Sonnet? Oh, go ahead, Anne-Marie.
She'll have to make an application to the court under the Cohabitational Act. Of course, to be counted legally as a cohabitant, you have to be, residing or living with the person for 5 or more years. So the first application has to go to the court for order to be, what we say, counted as a cohabitant. And under the law, she is entitled to the portion of the estate that would have been acquired during the period of their cohabitation.
Okay. You have anything to add, Ms. Lynch?
No?
Sonel, you have anything to add?
No, it's just the requirement is just somebody of the opposite sex. That's actually important something to note in terms of who the law will recognize as your cohabitant.
Yes.
Who has lived with you in a cohabitational relationship for 5 years or more, immediately preceding the application. So yeah, that's it.
That is okay.
There's another question, and hello, good evening, good evening. And this comes from Suan. And good evening, Suan. Thanks for joining us this evening. And what is the procedure to register a will? And what is the cost of the legal fee? So we would have answered that the last time, but it's nice. I'm happy that Suan brought up that question again of what is the procedure of registering the will and what is the cost of registering the will. And I would even throw in a third question there for Sonal. I'm giving this one to
Yeah.
Sonal,
Okay.
Ms. Lynch and Anne-Marie. I'm giving this one to Sonal. What does a will, if you do a will, do I have to go to an attorney to get a will done, or can I write my own will and keep it under my mattress? Does the will must be registered, or can I just keep it at my home? Sonal.
Hi, Mark. I actually would have loved to hear what was said, especially on the cost side on the last occasion, the answer to this in terms of cost, because we attorneys, we tend to be very slow to speak about cost in this way. But I'll start with the last question first. You don't need an attorney to create a will. All you need to do is create it the right way. If you understand what you need to do, if you have all the important things in a will, you've identified yourself, you have said who you want your executors, executrix to be. You have said this is the property you have and this is how you want it to be distributed. You have said anything left over, this is what I want to happen with it. You sign it, you have your two witnesses, you're fine. You don't need an attorney to create a will. Is it advisable that you have an attorney to create a will? Yes, of course. It's always advisable, but you don't need to have an attorney to create a will. It is one of those things, if you understand it, you understand it. You can create a will. Should you put it under your bed? Probably not. You want your will to be, remember you are going to die. And I know that sounds harsh, but you are going to die. Who is going to go and find your will on your bed? You want your will to be discovered after you die. So you want it to be in a place where it can be discovered. I know some persons even tell their executor, executrix, listen, I've left my will in the safe deposit box. So after I die, this is where you'll find it. I will not recommend you give copies of your will to anybody. That could backfire. But certainly don't leave it in a place where it cannot be discovered. And do not feel pressure to have it done by an attorney. It is not mandatory that you take your will to the probate registry. It is a good practice. I don't think it's practiced as much now as it was before, but you can lodge it in the probate registry. Why? Because if you come with a will, if you come to probate a will, the first thing your attorney will do is do a search to see if you have any wills in the registry. And if you do have one there, it's going to be found. Or if somebody has tried to probate a will for you, it's going to be found. So that is one of the practical benefits of registering your will. In terms of the cost, if you're dealing with the cost of the legal fees, I'm not sure strictly what cost you're referring to. If the cost of preparation of the will, the cost for probating the will, because those are very different things. The cost of preparing the will, I expect it may vary based on the degree of difficulty, based on I'll just stick with the degree of difficulty. If you have 5 trusts in your will and 20 grandchildren and 20 million assets, it's probably going to take some time to do. On the other hand, if you have a small estate, now the estates, the fees chargeable on the estates, they are regulated. So it's not as if your attorney could just charge you anything in terms of probating, though there are guidelines on how you charge based on the size and the value of the estate. So there's that inbuilt protection for you. I don't know which question you asked. I tried to answer both. But yes, that's my response on that.
You did answer both questions. And I'm going to take one more question from the persons online, and then we are going to address the trusts. Because remember, we said when we were doing part 2 that we would address the trust aspect of it. So, Sonal, gear up for the trust. So, good evening to Mark and your esteemed panel. Good evening, Mr. Maharaj. I have a question around what makes a will invalid. The question was asked prior to your panelist. A panelist would have indicated that a witness who is a beneficiary under a will can invalidate the will. However, I am of the understanding that while this is not recommended, that a witness be a beneficiary under a will for all reasons the panelists explained so well, that it will not necessarily invalidate the will, but that the witness will not
That is
be
the
able
gift, the
to
gift may lapse. You may
yes
not get the gift.
benefit under the will. I believe Section 45 of the Wills and Probate Act speaks to this, and any clarification would be appreciated. Thank you.
I think he's alluding to the gift itself may lapse,
Uh-huh.
and the person would not benefit
Okay.
from the gift itself. I think that's what he's.
In terms of the beneficiary and
If
so,
there is an instance where the beneficiary would have been
an executor.
a witness.
Uh-huh.
From the question I got
Yes.
that the gift itself may lapse.
Because you are old. Because what you would have alluded to the last time, and Sonel was very clear on it, that you cannot be a beneficiary and a witness. So because that can also
while it may not necessarily invalidate the will, the gift itself may lapse.
because it can be
I think that's
taken that you are influencing the person or something like that.
It can be inferred or implied.
Yes.
That I think that's what the question is. I think that's what Sonal got from the.
All right, well, so the business say thank you. I don't know if that is Franklin. Sona, before we go into the trust, do you have anything to add to that, or Ms. Lynch?
I have something quick to add. It's very good to see persons reading the act. Like most of the acts, you can actually read them. They're actually pretty. They're not as bad as people make them out to be. But it's exactly what Anne-Marie said. While we caution against doing certain things because they may lead to your will becoming invalid. They may lead to your will becoming invalid. That is a situation that may, while it may, you need to pick which one you want to be. Are you going to be a witness or are you going to be a beneficiary? Because if you're going to be a witness, that will override your ability to get anything. But there are situations in which being a witness and being a beneficiary in a context and in certain situations can lead overall to your will becoming not by itself. Let me make that clear. It can lend to a set of suspicious circumstances that do not assist you in your will being deemed a valid will. It can, in other words, be used as evidence that goes to duress, that goes to state of mind, that goes to different things. Because if you have a mentally incompetent person and all of a sudden the caretaker, I'm not hitting caretakers here, it's both the beneficiary, the executor, everything to the will. Suspicious circumstances. So while the act will say you can't get the gift, that can go on to poison the entire fruit. It can poison the whole situation. And in a situation like that, it can be evidence that leads to an overall situation that invalidates your will. So just steer clear of it completely. Don't go right to the edge and say, okay, well, you could still be a witness. You just won't get to stay away from it. Stay away from all. And that's why I said suspicious circumstances. Just steer clear of it. Mark, and before I speak about trust, and I know the time is going, just because I took a quick look at the act on the question asked by somebody who was logged in as e-box tenders. I'm sorry, I don't know what's your name. under the Act, under the 2000 Amendment to the Distribution of Estates Act, the children and grandchildren are both treated as the issue because they're both lineal descendants. I know we started to say it, but I'm not sure we made it clear enough. So specifically to your question, the lineal descendants will stand before the brothers and sisters. So that's in response to your question. The grandchildren will stand in the shoes of the children because they're lineal descendants. And they will be ahead of brothers and sisters in the distribution. Okay, so it's something, you could find it on Google. I thought it was an interesting question. So I thought let's just double check it. But yes, they actually do stand in the shoes of the children and will benefit before them because the Act defines issue as lineal descendants, children, grandchildren going down, which means even if you have great grandchildren, it actually means that they may even be ahead of parents, siblings, based on that definition of who the lineal descendants are. Yeah, so it's an interesting area. The law is always moving and developing, so you kind of need to keep up.
It seems so very confusing. Thanks very much, Sonel. And we have, 15 more minutes. It's always so amazing that when you are having such fun and getting such clarity. Remember the last time we would have said in terms of communication being, if it is done right, it is so very attractive, and we are communicating very attractively this evening. And Sonel, let's use the time in understanding what is a trust, how it is set up, who has the power or the authority at that point in time, and what are the ins and outs of someone setting up a trust. So the floor is all yours, Sonel. Let's find out or discuss now about trusts.
Thanks, Mark. I'll be quick, and I'll rely on my co-panelists to jump in as needed. What is a trust? Strict definition. A trust is an equitable obligation binding one person, a trustee, to deal with property over which he has control, the trust property, for the benefit of other persons, beneficiaries. Three things came out in that. You have somebody who has an obligation to deal with property. So you have a trustee, somebody who's been put in a position where they have an obligation to act. You have two, trust property, some property that the trustee has to control. And three, beneficiaries. The trust property is not the property of the trustee. It is not for the trustee to make their own profit and do what they like with it. They manage it and they control it for the benefit of the beneficiaries. Three important elements. So that if you have, and I'm bringing it right into the context of the will immediately. If you have, for instance, minor children or minors in your life generally, and you want to leave something for them in your will, and you want to leave it for them, the person is 5 now, but you want them to be able to get this house when they turn 21. You want them to be able to get this money when they become 21 years old. You can create a trust in your will by saying this property, which will be the trust property, is to be managed by or held by this person, could be an executor or somebody else, for the benefit of this other person. What that does is create for the trustee fiduciary responsibilities, duties. So they have to now manage that property in a way that supports the interest of the beneficiaries. For instance, a beneficiary can sue a trustee. A beneficiary can say, this property was left for me. You allowed it to fall into waste. You did nothing with it. You didn't manage it. You have lost this property because the beneficiary is the person for whom the property is there. So that at the end of that period, when the person turns 21, and the trustee can now pass the full legal title and everything over to the beneficiary, that's the end of the trustee's work. Basically, precisely, that's what happens. The trustee, that is the end of their work. Now, a good way to understand trust, there are different levels of ownership. That's one way I could explain it. And I say that because you will notice in my definition, I said the person has an equitable obligation. You have a legal obligation, you have an equitable obligation, because you have a legal interest and an equitable interest. What this means is you have your property, it is legally yours, but just like you can give the person living in the house behind you that right to pass through your property, and they have an equitable interest, it's not their own, but by constant use and by you giving them permission, they now have an interest. You've given them something so they could use. It's the same way it operates with your trust property. You as or whoever the trustee is, they hold the title, but they're not holding it for themselves because it is for the beneficiary. Until such time as the beneficiary now has both the equitable and the legal interest. I know that's a lot, but I hope it was clear enough. But the idea there, as I said, three things: a trustee, trust property, beneficiaries. Trustee holding trust property to the beneficiaries. The trustee then has duties and responsibilities to the beneficiaries. And the way it's normally used in wills is when you have a minor. It doesn't have to be a minor. There are situations when, for instance, it may be someone who has some sort of diminished capacity or some inability to deal with this property right now. So you say, this person, they don't have the capacity or the capability to deal with this gift right now. So instead of giving them $1 million, I'm appointing this trustee, and this trustee will ensure that they receive this allowance from this, but I'm not going to pass this whole thing to them. This trustee is going to manage it for them. They're going to make investments. They're going to some trustees rent out property and hold monies, increase the value of the property for the beneficiary. But that is the idea in a nutshell of what a trust is in the context of a will and how it works.
Thank you so very much, Sonal, for clarifying that.
That's a good, simple explanation.
And not as confusing as you told me before.
Because there are so many levels, they could become,
a bit confused. But that is quite clear, at least to me, of what is trust and who is responsible. And I'm even guessing that if I'm entrusted to hold something on behalf of the beneficiary, whether they come of age, and I misuse or misappropriate, then based on what Sonal is saying, is that the beneficiary can in turn sue me. So if I have $1 million and I invest that $1 million in stocks or bonds or whatever have you, and it so happens that I lost it because the market tanked, and and now the beneficiaries of age and looking for his or her $1 million+ and there's nothing to show, I would now have to find this money to pay them back as a trust.
But if I recall, the trustee would have powers to invest too. And of course, he must use, some level of wisdom and,
But I use
you can't be doing it willy-nilly. So, but as with all investment, there's a level of risk, but you can't invest the funds or invest, remember it's not yours, you're doing it for the
Yes.
benefit. So you must do it in a way that you have given thought and gotten good advice as to the, the investment. You were not negligent in how you
Manage the
how you manage the
portfolio.
portfolio, how you invest it.
Care to throw in a 2 cents there, Sonal, on as we wrap up?
I'll try 1 cent, which is, it is not meant to be a noose around your neck, the trust. It is not that if something happens, anything absolutely goes wrong, you've done a bad job and you're in trouble. You just have to be reasonable, and as Anne said, you don't act negligently. You don't act in a way there's no negligence on your part. But life happens and things happen. So it's not going to be that there was something that happened and okay, because you do trust, you now have to find the money. That's not how it works. If you are negligent, reckless, unreasonable, then you put yourself in trouble because you have breached the trust. So I don't want you to feel like if somebody comes and asks you to be the trustee that I'm not doing this because this is some sort of death sentence or a noose or a terrible obligation. But yeah.
Thank you, Anne-Marie. Thank you, Ms. Lynch. It is
You're
now
welcome.
7:25. And the last time we were here just for 1 hour. And that hour flew very quickly.
Yes.
We extended it
A half
by
hour.
half an hour. And that too went by very quickly because it is a lot. And as we said at the beginning of the webinar, the information is going to be very rich. It is going to be information that you can take away and actually start putting structure to your life in terms of these are my assets. These are the persons to whom I want it distributed. So at least I know that when you die, you don't know what is happening. But at least when you are living, you have a level of comfort knowing that you put things in place so that your loved ones would be able to inherit your assets as you so desire. So we have covered it, the wills and trusts. And I would just give each one of you 1 minute for closing remarks. So we will start with Ms. Lynch, your closing remarks to our fellow cooperators out there, and of course the wider community, because this goes on Facebook, Instagram, YouTube, and the website.
Someone told me they saw me.
You're all over the world, Anne-Marie.
I was quite surprised.
So, Ms. Lynch, closing remarks.
Fellow members of WESCU, I hope that you have appreciated this seminar to the point where you don't feel scared to speak about what you're going to do if you die. And I think I really hope that more people will think of having wills and trusts with their assets to avoid problems in the future. Thank you so much for taking part and listening to us.
Thank you so much, Ms. Lynch. Anne-Marie?
I want to say that this has been an enjoyable experience. And I do hope that the members, the listeners, those who logged in, were able to appreciate and learn a lot from the information. And the information has given you the impetus to look at your assets. Don't wait until, we like to say, my father used to say, he's not going to bed until he's ready. He's not going to bed until he's ready to change his clothes or something to that effect.
Yes.
Meaning that he wasn't in like mind to make a will. He died without making a will. So
It's
I don't,
important.
it's important. We don't know when we are going,
Yes.
and life is so unpredictable. So I do hope that you have learned a lot, and it has given you a new outlook on how to prepare, for your loved ones, your children, especially if you have young children. It's so important because we don't know. Sometimes you leave children and they accept whoever take care of them afterwards, and they're worse off.
Yes.
And as as a parent, we will always, when the children are young, that's one of the things was always of concern, to put things in place to make arrangements for your child, your children. So I hope you have learned a lot from the last two webinars.
Thank you so much, Anne-Marie. Sonel, as closing remarks.
First, I want to say thank you so much to the team at Western United Credit Union for the invite. It has been very good. I want to say thank you to the fellow panelists and Mark, who moderated and did an excellent job. Again, I express my regret at not being physically there, but I enjoyed the session nonetheless, and I hope that it was helpful and useful to persons who listen, and that they will continue to check and gather information and do what is necessary. Don't sit on it and wait on it. Don't think that you're too young. Do what needs to be done in the interest of yourself and your family. So yes, thanks again.
Thank you so much, Sonal. Thank you so much, Anne-Marie. Thank you so much, Ms. Lynch. Ladies and gentlemen, there you have it. And maybe sometime in the near future, we would indeed have this again, part 3, because there's so much still to discuss, and then we will have Sonel in-house, but it may not be right now, it will be in the future, because I really enjoyed it. And as one of my former lecturers used to say, and she has instilled it in us, sharing for success. So the information that you would have attained here this evening, don't be selfish and keep it to yourself. Share it, share it, share it. As the presenters will say, I am Mark Ferret, your host for this evening. Good night, and I look forward to seeing you again.